Welcome to the Kane, Shannon, Weiler Employment Business webinar.
I'm going to turn it over to Chris, who will discuss the really significant WorkSafe issues that are presented.
Great. Thanks very much, Mike. So I'm going to talk a little bit about the Workers' Compensation Act. I've been practicing in this area for about 10 years, and with the NDP winning the majority government in the recent election, changes that have been in the works for some time are going to come to bear in the coming months and years. So for this reason, understanding employers' obligations under the Workers' Compensation Act has never been more important. I'm not going to go into a full history of workers' compensation and how it came to be, but in essence, it's a system of compulsory no-fault insurance that's administered by the government. Its origins go back to the 19th century, to Germany actually, and it was introduced in the United Kingdom and the United States. And in 1910, Sir William Ralph Meredith, who was the then Chief Justice of the Ontario Court, proposed the system be adopted in Ontario and ultimately in Canada. And the whole system is based on what's known as the historic trade-off or historic compromise. And basically, this historic compromise is workers lose their ability to sue the employer or their fellow workers in court for injuries that occur in the workplace, but they gain a compensation system that depends neither on the fault of the employer nor its ability to pay. So it's an employer-funded insurance scheme. So similarly, employers are forced to contribute to the mandatory insurance scheme based on their payroll, but they gained the freedom from potentially crippling liability to pay for the negligence of workers and the injuries of workers that occur in the course of employment. So an employer's quarterly premiums for WorkSafe are determined by looking at two things: looking at the firm's assessable payroll and multiplying that by the firm's premium rate. And the premium rate is calculated in two ways. First, it looks at the base rate, which is kind of the rate that applies to every employer in a specific industry, and that looks at the nature of the business, which an employer can't do anything about. It is what it is. But WorkSafe also looks at the employer's experience rating, and it applies that experience rating to give a net premium rate. So an experience rating looks at the average claims costs for that particular firm. And if you have less claims or less expensive claims on average than the other people in your category, you can have a discounted net premium rate and therefore lower premium costs. If you have higher claims or more expensive claims than average, your premium can go as much as 100% higher, so it can double, which can effectively double your WorkSafe BC premium costs. So for that reason, employers have an interest in understanding and managing WorkSafe BC claims because it does ultimately go to the bottom line. So since 2018, the BC Labour Minister, Harry Bains, has commissioned no fewer than 5 comprehensive reports reviewing the employer-funded compensation system. And these reports are not small endeavors. These are lengthy, comprehensive studies done by various industry experts and with significant consultation from stakeholders. Now, there's been varying degrees of participation from the business community in these studies, which I'll talk a little bit more about. But at KSW, we have the privilege of being part of a group called the Employers Forum. And basically, it's a group that lobbies and represents the business community in relation to WorkSafe BC changes. So through our participation in that group, we're able to get some great insights into changes that are coming, and we're able to participate with the big players in the business community in determining how those changes are rolled out. So I'm not going to review each of the 5 reports in detail. We provided some links to the reports for you to review on your own time. But I'll go through them briefly in chronological order. The first report is called the Petrie Report. It's from April in 2018, and Paul Petrie was a former vice chair of Workers' Compensation Appeal Tribunal, and the report is called Restoring the Balance. And the title itself is kind of telling. Clearly, the report is aimed at providing more benefits for workers and restoring what was perceived as an imbalance in the system that the Liberals had brought in that favored employers and business and capital. There were 41 recommendations made in the Petrie report to provide a more worker-centered approach to the system. These recommendations have not been implemented in full at this time, but they were influential in the recent amendments to the Workers' Compensation Act, which I will get to shortly. The second report was called the Boggio Report, and this was done in December 2018. This was a report by Terry Boggio, who was a longtime WorkSafe BC senior advisor. And the purpose of this report was to look at what are the options for spending the $3 billion surplus that had accumulated in 2008. Now, in May of this year, Minister Baines made an announcement that the surplus had all but vanished because of the economic decline after COVID and the impact of that on WorkSafe BC's investments. We don't have the full details of that. We don't know if that's actually the case. And it's not clear at this time whether some or all of that surplus has since been restored due to the markets recovering. But in his report, Terry Boggio reviewed 9 options for using this $2.6 or $3 billion surplus. And I won't go into all those options today, but again, those options were influential again in some of the changes that have been implemented in the new amendments this summer. The next report was called the Helps Report. It was from August 2019, and it was prepared by Lisa Helps, who's a criminal defense lawyer in Vancouver. This report was specifically responsive to 2 sawmill explosion incidents where there were fatalities in British Columbia. And she looked at those incidents and WorkSafe BC's response through a health and safety lens. And she made 11 recommendations relating to workplace health and safety, most of which created more significant liabilities or penalties for employers or more onerous obligations for employers in relation to health and safety. And health and safety regulations and provisions are often much easier to push through the legislation because safety is important to both the employer and the worker. And so many of these recommendations made their way into the most recent amendments to the Act, which happened this summer, and I'll go through in a moment. The fourth one is called the Parr Report, and it was from February of 2020. And this was prepared by Jeff Parr, who's the former Alberta Deputy Minister of Labour, and is now the chair of the WorkSafe BC Board of Directors. So again, he's an industry expert, and the purpose of his report was to essentially look at the 3 previous reports and determine which recommendations and options were appropriate to include in amendments this year that the government was planning to make. So he made 14 recommendations for amendments to the Workers' Compensation Act, and many of those were in fact implemented. And so one of the comments on the Parr report was, this report the research was done, pre-COVID. So when the $3 billion surplus was there, there was economic stability, and there was a reason to think about increasing worker benefits without really penalizing employers or having to take money out of the accident fund. We could use the surplus to bring in some of these ideas that Petrie had envisioned a couple of years ago. Of course, COVID happened, and the economy grinds to a halt. Businesses are shutting down, and the NDP decided nonetheless to go ahead with the amendments and to implement a lot of these recommendations, some of which are potentially going to create significant costs. So there was a massive protest and resistance from the employers forum and the business community when Minister Baines announced that they were going to go ahead with these amendments. There was a strong letter sent by the employers forum, but it was effectively ignored, and the amendments went through. So we now have an amended Workers' Compensation Act. So I'm going to review some of those amendments here. The bill was introduced in July of this year. It was passed into law in August. And at this stage, I think it's important to note that these amendments are stage 1 of probably 5 stages. that we're going to see. And these amendments are actually quite conservative compared to some of the ideas that we saw in the Peacher report and some of the ideas that we're going to go through in the fifth report, which is called the Patterson report. But what I'll do is I'll give a brief summary of the key amendments that have come into force now, and then I'll look at what's potentially to come. So one thing that was changed is they've increased the maximum insurable earnings from 87,000 to 100,000. So the idea behind this is there's a statutory ceiling to the total amount of benefits a worker can receive, and so it used to be 87,000. So if your worker was earning 100,000 or 150,000, their benefits would be based on that statutory cap of 87,000. This has now been increased to 100,000, and the idea is, wages have increased over the years, and we don't want to be, paying out less than workers' salaries if they're, earning 100,000 or more. Secondly, and very significantly, there's been a change to the assessment of pensions under the Act. So currently, the default way to assess workers' permanent disability pension is using what's called the loss of function method. And that method doesn't look at the workers' lost wages that they would have pre-injury and post-injury. It looks at the level of impairment they've suffered from the injury. And that's done through a functional assessment. And there is a process where the WorkSafe officers will assign a percentage of disability to the worker. So they might be assessed to be 5% impaired from working at their full capacity, or 10% impaired from working at their full capacity. If that's the assessment, then that worker will be entitled to a pension that's based on 5% of their earnings or 10% of their earnings, up to the age of 65 or whatever the retirement age is deemed to be. It's only if the worker suffers what's called a significant loss of earnings between the pre-injury situation and the post-injury situation that WorkSafe will consider a second method of assessing the pension, which is called the loss of earnings pension. So generally speaking, so long as the earnings between the pre-accident scenario and the post-injury scenario are not significant, employers are not being faced with these loss of earnings pensions, which can be much greater than the loss of function pensions. The rule change now is that WorkSafe is going to do an assessment of both pensions, both the loss of function and the loss of earnings, and whichever is higher, the worker is going to get. So it doesn't matter if the difference is significant or not. They're going to do the two assessments, and the worker is going to get the better of the two. So ultimately, this is going to lead to higher pension awards and greater claims costs for employers. Another change that's significant deals with the setting of a retirement age. So presently, the default age for retirement is 65, and that basically sets the date where the WorkSafe benefits will stop, where the coverage will end for these permanent disability pensions that I mentioned. So presently, the worker's retirement date is set at the time that the pension is assessed. So that's usually shortly after the injury or at the time that the injury settles down into a permanent condition. So for a young worker, that might be when they're 30 or 35, and the board will set their retirement date at that time, which many perceive as unfair because who knows when they're going to retire when they're 30 or 35. It's very difficult to present evidence that you're going to work later than 65 when you're only 30. And so there's a lot of cases where the default age of 65 is being set, and people don't really have an opportunity to present evidence that they were intended to work later. So what they're going to go to now is they're not going to assess the retirement age until the worker is actually close to the age of 65. And so the retirement age is going to be left open. And when the worker gets closer to retirement, like age 63, the board will do an assessment and look at, is it likely that they're going to continue working past 65? And ultimately, we think this is going to result in more claims going past the age of 65, and again, higher claims costs. So these two changes with the pension and the retirement age are going to come into effect in January of 2021, whereas all the other changes have come into effect now. Some other important changes. As of now, before you can access healthcare under a claim, a worker needs to have that claim accepted by WorkSafe. So some entitlement officer needs to have made an adjudication and assessment of whether the injury was work-related. The worker then becomes entitled to the funded benefits such as treatment and wage loss. The change they're making is in urgent healthcare situations. They are going to provide healthcare such as treatment, counseling, those types of things when it's urgently needed before they've actually accepted a claim. And so this creates an issue of what happens to those costs if the claim is ultimately denied. Is the employer still on the hook for those costs, or should they properly be switched over to the public health system? So that was one of the issues raised by the employer community when these changes came in, and it looks like the employers are going to be stuck with those costs, even though they're not necessarily related to a work injury. Another big change is currently there's a 1-year limitation for somebody to report a work injury, and if somebody misses that 1-year deadline, they have to show that there were special circumstances that existed that prevented them from making the report. So in a case of, say, PTSD, they might be able to say that they were sufficiently impaired by their symptoms. They weren't able to seek the advice they needed to make the claim, that kind of thing. But it's a fairly high burden to explain why you didn't make that claim within a year. And it actually prevents a lot of those claims from coming in. The change that's been made here is that 1-year limitation is going to be gone. So in specific mental health claims, workers aren't going to be held to that deadline. And our anticipation is that this is going to again result in a lot more mental health claims and higher claims costs. There's a couple other things that I won't go into. As I mentioned before, the HELPS report talks about health and safety changes and recommendations. And so a lot of those were implemented in these new changes as well. There seems to be a bit of a shift from dealing with health and safety violations in an administrative way through fines and penalties to potentially dealing with them in a criminal or a quasi-criminal way, which of course is concerning to employers. So WorkSafe has been given some more procedural tools to lay criminal charges for health and safety violations instead of doing an administrative fine. So they have greater powers for search and seizure. They have greater powers for accessing the charge approval process through Crown Counsel. And the court actually has specific powers in remedies that it can impose on employers if they're convicted of health and safety violations. And one of those is that the court can compel employers to publish facts about the offenses either in a newspaper or in a company-wide newsletter. So there's this kind of idea of shaming, and is something that obviously an employer wouldn't want if they are found to have committed a health and safety violation. That's the court can have them, send out a newsletter detailing all of that, and that can go as well to the public in a newspaper. So those are things that just reinforce the need to be cognizant of health and safety obligations, and to certainly, seek advice if you are faced with an investigation, because the penalties and the consequences can be serious, and they can now potentially be criminal. Another important part of the amendments is what's called Schedule 1 of the Workers' Compensation Act. So Schedule 1 has a list of conditions and diseases that if the worker proves that they have the disease, there is an automatic presumption that the disease was work-related and therefore compensable under the Workers' Compensation Act. And there was a big push by the government to have COVID-19 added to Schedule 1 of the Workers' Compensation Act to simplify and make it easier for people who contract the virus at work to have that claim accepted. So again, there was a big protest on this because the government skipped the mandatory review process that usually occurs, and usually it goes to scientific studies and all this kind of stuff to determine the connection between, the workplace and the disease. That wasn't done in this case. It was fast-tracked through to the Schedule 1. And, there's a concern that we're taking something that's a public health crisis and something that's properly dealt with through public health resources and posing that on the workers' compensation system and having employers pay for those costs through the accident fund. So the one kind of saving grace to this is there is a condition that says the Schedule 1 presumption only applies if you are in an occupation that has significantly more exposure to the disease than the general public. So this probably will be limited to the healthcare sector and other industries where you actually do have a greater exposure. It's not just going to be an automatic presumption for every single employee. Some interesting statistics. As of the end of October, there's been just under 1,500 WorkSafe BC claims for workers with COVID-19. And of those, 445 have been allowed, 720 have been disallowed, and 186 are pending. So at this point, we see that there's still less than 50% of claims being allowed. But I expect that with this new presumption, that ratio is probably going to change, where we're going to be seeing more accepted than not, particularly in the healthcare industry. So that's a picture of where we're at now. Where are we going? I previously mentioned the Patterson report, and this is the fifth and final report to consider. This was a full workers' compensation system review done by Janet Patterson, who's a former labor lawyer with strong connections to the BC Federation of Labor. And she had looked into changing the workers' compensation system back in 2009. And when she started her review in 2019 at the request of Minister Baines, it quickly became clear that she was going to go beyond the terms of reference that had been provided to her and look at doing a full overhaul of the entire workers' compensation system based on the ideas that she presented to the BC Federation of Labor in 2009. So as a result of this, there was a strong reaction from the employer community, and the 46 employer community partners actually formally withdrew from the review and refused to participate, as they said on the record that they lost confidence that the review would be done in an independent manner. And so the review proceeded without a lot of input from the employer community. And the report is a mega report, and it's no less than 517 pages. So I'll admit I have not reviewed the whole thing myself, but I intend to. And it's basically an expansion of the worker-centered approach that was mandated in the Peachy report. So there's 102 recommendations, and at this stage, it's not clear, which ones will be implemented and when. But I did want to highlight a few, so you can get a sense of what's maybe coming. Some of them are very practical and reasonable. For example, allowing email communications between the board and the participants. Right now, everything happens by letter. It's a slow and cumbersome process. Secondly, there's a proposal to have one case manager assigned to a worker's claim from start to finish. So again, that's something that I see regularly is there's 4 or 5, 6 case managers throughout the claim, and every time a new case manager comes on, they don't know anything about it, so you get inconsistent decisions and all that. So some of those things I think are going to be good, but there are many more significant substantive changes, most of which will probably result in more claims, more expensive claims, and ultimately greater costs for employers. So I'm not going to go through them in detail, but a few highlights. There's a proposal to change the appeal period to the Workers' Compensation Tribunal. It's currently, you have 30 days to do it. They want to change it to 90, which is consistent with the review period for the first level of appeal at the review division. Again, that's going to bring in a ton more claims because a lot of people don't appeal within the 30 days, and then their appeals are barred. Currently, vocational rehabilitation appeals end at the review division level. So the proposal is to allow one further level of appeal to WCAT, Workers' Compensation Appeal Tribunal. Again, it's going to be more appeals. There's a proposal to add compound interest to any retroactive payments that are made to workers. So if a worker wins an appeal and is awarded 6 months back pay, they're looking at adding compound interest to that payment. Currently, there is none. There's proposals to establish other advocacy groups, which would be in addition to the Workers' Advisor's Office and the Employers' Advisor's Office, which are currently free resources for workers and employers. There's a suggestion to establish some additional advocacy groups for other types of workers. There is a proposal to establish protection and a remedy for a worker who faces retaliation for filing a compensation claim. So currently, I'm going to talk a little bit about prohibited actions. So currently, employers cannot retaliate against a worker if they raise a health and safety issue, but there isn't technically any prohibition against, or there isn't a way to complain against an employer if a worker thinks they've retaliated against them simply for the fact that they've made a WorkSafe BC claim. So Patterson would have the system change to add this additional type of complaint, which again is going to create more litigation, more costs. There's a proposal to give WorkSafe BC the jurisdiction to rule on human rights matters such as discrimination and the duty to accommodate. And Mike will go into that in some detail, but right now we have the Human Rights Tribunal, who has the exclusive jurisdiction along with arbitrators in the labor context to deal with those sorts of things. So adding another layer onto the WorkSafe system is going to cause confusion. It's going to cause inconsistent rulings, and probably is just not going to be a good thing. Another big one that's proposed is to expand the definition of mental disorder to include not only accepted psychological conditions that are assessed by a psychiatrist or psychologist, but any psychological injury. So, right now, these sorts of claims are limited to things that a psychologist or psychiatrist would diagnose, things like depression, panic disorder, anxiety, PTSD, that kind of thing. Expanding the definition to, these vague concepts of stress or emotional upset, again, is going to open the floodgates probably for many, many more mental stress claims, which I'll talk about in a little bit. I'm going to go to the topic of bullying and harassment. And I've just been told I've only got 5 minutes, so I'm going to fly through this. And Mike will talk a little bit about the concept of harassment in the human rights context. But I wanted to touch on it in the WorkSafe BC context as well. There's 3 ways that WorkSafe can be involved in bullying and harassment. And I've put a definition up there, which I think is a good definition to look at and include in your policy manuals. It's any inappropriate contact or conduct or comment by a person towards a worker that the person knew or reasonably ought to have known would cause that worker to be humiliated or intimidated, but excludes any reasonable action taken by an employer or supervisor relating to the management and direction of workers or the place of employment. So that's kind of the basis of how WorkSafe looks at bullying and harassment. And there's 3 ways, as I said, that they can become involved in bullying and harassment. First, as a regulator of the employer's policies and procedures. The employer has a health and safety obligation to have a policy on bullying and harassment and to follow that policy. So the policy must include, investigations procedure, the roles and responsibilities of the parties, and how records are going to be kept. And so if you don't have that, you need to make a policy. It's something that should be in your employee handbook or manual. And if you don't have it, WorkSafe does an investigation arising from a complaint. They could note that, send it to their prevention officers, and you could be, penalized. So that's the first way that they can do it. The second way is something I mentioned before, these mental stress claims or mental disorder claims. So a worker that suffers mental stress injury in the course of employment can make a claim for WorkSafe BC benefits under Section 135 of the Act. I've set out the section of the Act there for you to look at, and basically it requires a number of different things, but at its core, there needs to be either a traumatic event or a significant work-related stressor that's caused the mental disorder. The mental disorder itself has to be, as I mentioned, specifically diagnosed by a psychologist or a psychiatrist. The mental disorder cannot be caused by a decision of the employer that relates to the worker's employment. So this is known as the labor relations exception, and it's a very important exception that, again, the Patterson report wants to narrow. So some statistics, mental disorder claims are on the rise. You can see in 2017, there was just under 4,000. 2019, there was 5,500. So they're increasing, at the rate of approximately 1,000 claims a year. You can also see on the left side of the graphic that more and more claims are being allowed. So in 2019, 63% of the mental disorder claims were allowed. And I expect and anticipate that 2020, the numbers are going to be even higher. And I think that's going to continue to increase given the toll that COVID-19 is playing on mental health, and also the continued prevalence of the Me Too era. So I'll talk a bit about bullying and harassment investigations. Where a worker makes a mental stress claim, WorkSafe BC is mandated to go into the workplace and do a harassment investigation. And this can cause some serious issues for employers because this investigation will occur regardless of whether you as the employer are conducting your own investigation. And WorkSafe BC is going to go in there, interview witnesses, and make findings about what happened in the workplace, which may not necessarily be the same conclusions that you come to or your investigator comes to if you've retained a third party. So, if you are facing an investigation that WorkSafe has done and you disagree with the results, you do have a right to seek a review of that. And sometimes the implications of the investigation can be far-reaching if you've decided to discipline or not to discipline the person that's been accused of the bullying and harassment. I'll go now quickly to the third aspect in which we see bullying and harassment in the WorkSafe. That's prohibited action complaints. So these were formerly known as discriminatory action complaints. And basically the essence of them is to punish employers for retaliating against workers who raise legitimate health and safety concerns. So if somebody raises a complaint and that complaint relates in any way to occupational health and safety, if the employer takes any sort of negative action against that person because of the fact they raised a complaint, that is called a prohibited action. So a prohibited action is defined broadly. It can be any sort of a negative or adverse effect relating to that person's employment. It could include, discipline, suspension, demotion, lower wages, termination. It relates to bullying and harassment because bullying and harassment is considered an occupational health and safety issue. So nearly 50% of prohibited action complaints cite bullying and harassment as the safety concern that led to the alleged prohibited action. And we can see from the graphic there that, again, bullying and harassment related prohibited action complaints are on the rise. There were 456 complaints in 2019. That's up from 377 in 2015. And so it's important to recognize that when you do have a bullying and harassment complaint, to tread very carefully and consider any liability you might have under these provisions if you down the road decide that you need to make changes to the person that has complaints employment. If that decision is in any way tainted by the fact that that person has raised a health and safety issue, you may be faced with a discriminatory or prohibited action complaint. And the reason they're so scary is the remedy. It's a make whole remedy that WorkSafe provides somebody who can establish liability for a prohibited action complaint. So if you have terminated somebody and that person can prove that it was tainted by the health and safety complaint, you can be liable either to reinstate them, bring them back to your workforce when clearly you didn't want them there, or have to pay them all of the wage loss that they've suffered since the termination. So if that person hasn't worked, and these complaints can take up to a year or 2 years to get adjudicated, if for whatever reason that person hasn't worked, you could be on the hook for a year or two of wages. So again, seek advice if you're faced with one of these complaints. It's important to get advice early in the process because the investigation is done within a couple of days of the complaint. And if you're stuck with having to do an appeal, it's more challenging for us to help you. So those are essentially my comments on bullying and harassment. I was going to do a COVID-19 update. I will skip that. We've done previous seminars and blogs on the COVID-19 safety plans and the refusal to work process. We've linked the blogs to the slides, so you can go there, talk to me after. I'll leave with a quick stat. As of October 29th, WorkSafe had issued 627 COVID-19 work-related violation orders, and that was based on 17,000 inspections. And so for the most part, employers are doing pretty good at putting together their plans, making sure that things are safe. And my impression and experience in hearing from clients has been that the prevention officers are focusing on education and guidance as opposed to penalizing people that might be technically in breach. Okay, that's it for me.
Okay, Chris, that's excellent.